All right, call the case of the people of the state of Michigan versus Daniel Leon Barnett, 2023285. Mr. Bush is his attorney, Mr. Gabriel is the prosecutor. We were in court on June the 8th for his status conference. The case was not resolved, indicated that we needed a hearing on defendant's objection to people's notice pursuant to MCL 768.27A. And also defendant made a oral motion to represent himself. And I indicated that I would hear that on today's date also. He was notified of the hearing and he is not here today. Mr. Bush?
Your Honor, I was handed a message just a few moments ago. We were on the record in another matter. He called my office this morning. He does not have the ability to connect with the court by video. And apparently he's not in the Sturgis community. He's certainly free to come to my office and use my second phone. So we are not in a position to move forward today on the motions.
Well, yes, we are. I mean, he called in. He clearly has the ability to get into the courtroom by Zoom. He could do it by telephone or by Zoom.
He could participate by telephone if the court's willing to.
I mean, he could participate by Zoom. That's how he's participated every time by phone. So his motion to self-represent is denied. And do you wish to agree to proceed on his motion or on your motion regarding the objection? It's not your motion. You filed an objection. You waive his presence and ready to be heard on that?
I would do that. Okay,
go ahead. You've objected to the statutory notice under 768.27. First, let's hear from Mr. Gabriel as to why. Well, I'll hear from you, Mr. Bush. It's your objection.
Your Honor, reviewed the file carefully. I guess my biggest concern is the length of time that's passed. I believe it was upwards of 13 or 14 years from the prior acts that Mr. Gabriel is is trying to ask to be put before the court. And I think that is significant. If the court looks at the case law in this matter, there's probably too much of a gap between the events. And I would ask the court to not allow the testimony or the police report of the prior CSC matter.
Go ahead, Mr. Gabriel.
Thank you, Your Honor. Your Honor, as the court's aware, with the people's notice pursuant to the statute, I did attach, and I believe the court also then has a copy of the police report from the Sturgis complaint dated 2005. When one runs an individual's criminal history, for whatever reason, that conviction, which was a conviction of criminal sexual conduct in the second degree, doesn't show up. So what I did was I asked Sturgis to look into it, and they discovered this report and the conviction that he is in fact, which is what requires him to report under the Sex Offender Registration Act. Time is not an element in the legislature's decision to pass the statute. I looked for guidance under People versus Watkins, the Supreme Court case, which looks at the potential conflict between 404B and 768.27A. The court's well aware that in viewing situations in which prior bad acts are filed, the whole idea here is, in that situation, not to allow propensity to be a governing factor. And in fact, propensity is not why 404B is in existence. We're not able to use that to show an individual's propensity to commit a crime. That's for motive, scheme, intent, things of that nature. The legislature decided, and I'm not exactly sure what year it was. I think I was a defense attorney then. It might have been a prosecutor then, I can't remember. But they passed the statute. And in Watkins, 491 Michigan 450, decided in 2012, the Supreme Court basically said that the statute will govern how we proceed, that the statute in this case does take a back seat to 404B. The court does, however, say that the statute does remain subject to MRE 403, which says the court may exclude relevant evidence if the danger of unfair prejudice, among other consideration, outweighs the evidence's prohibitive value. But the court continues. Judge Sahara, speaking for the majority, indicates that in applying the balancing test in MRE 403 to evidence admissible under 768.27A, the court must weigh the propensity inference in favor of the evidence's probative value rather than its prejudicial effect. So then we look at the two instances, and it is somewhat, it's surprising as you read the police report as to what Mr. Barnett both admitted to and was convicted of, the closeness to what he's accused of now. The fact that it was a significant period of time later, I think that might have some effect on theft cases or drug cases. But most studies have shown that an individual that has a deviant sexual characteristic is not something that you're cured of. It's not something that goes away with time. It's there, and it's a question whether the person acts on it. So my contention is that if the only basis to say that this is too prejudicial is because it happened back in 2005, when in 2005 he was accused and convicted of basically groping his 14-year-old stepdaughter, looking down her blouse and feeling her breasts. And here in 2000, and I think it might have been 18 or 19, I know we have a 20 case, but it started out in district court the year earlier. He's accused of going with his now live-in girlfriend's daughter. In other words, he was in the household, he lived there, taking her to Walmart, and on the way back, groping her, fondling her breasts, reaching her vaginal area, all of which is set forth in the preliminary examination transcript. And that's why we're here. The two circumstances are almost mirror images of each other. And if this was 404B and the court was weighing propensity against the prosecution, I think I could have some difficulty. But under the statute, this is a listed crime against a minor. The first victim was 14. This victim is 15. And those are both listed offenses under the statute of criminal sexual conduct, second degree. Quite frankly, had this shown up on his lien when this case was issued, in all probability, Mr. Barnett would be looking at a 5-year mandatory minimum as a subsequent sex offender. So I do believe that it's relevant. It helps prove that on this date, at this time, he committed this same crime, and it corroborates the victim's claim. He did it before. Thank you.
Thank you. Mr. Bush, anything further?
No, Your Honor.
All right, I'll deny the objection and allow the evidence to come in. It does meet the statutory requirements as a crime that occurred involving a minor. The length of time is not a factor in and of itself. And here, I would think you'd have a strong argument for 404B inclusion. It shows a pattern that's almost identical. 14 to 15-year-old stepdaughter is making accusations that he touched her breasts, just as it had happened before. And although the statute allows it to be used for propensity, 404B would only be allowed to use it for, a scheme, common scheme or plan. But yes, it is allowed under the statute. And it is a difference from 404B evidence that can't be used to argue propensity. So again, though, we need to talk about how you intend to introduce that with the testimony of the victim of the first case versus just reading a police report and the confrontation issues there. But we will go ahead with, I'll indicate the objection to the notice is denied and we'll proceed. And then we'll get it set for another status conference sometime in the next month or so.
Thank you, Judge.
Thank you. All righty. I'll send orders out on both.
Thank you, Your Honor.
Thanks.